Welcome to Looking at Legal Stuff. Today we have a review hearing on the DV docket where a man and his pregnant wife, who was also the victim, beg and plead with the judge to lift his no-contact order so he can move back home. But the judge tells them that he's unwilling to do that until there's proof of compliance with treatment in his file. Will they listen to what the judge is trying to tell them? Let's find out.
Bradley Burlington. Okay, there we go, Mr. Burlington. Okay, and then Brianna had asked the court to modify the order, and I kind of not sure your documents formatted correctly when they got filed in the court file. It's a little bit.
No, you didn't get them?
No, I've got them. They're just kind of a little bit messy, so it's hard to read them, but.
Oh, I apologize about that.
Okay, so this case is a diversion, a little bit different. So Mr. Burlington's not on probation. It looks like this diversion was granted just a couple of weeks ago. I remember doing it. And then it was just a day or two later that this request to change the order came in. Okay, so since he's on a diversion, I don't have any information about his level of compliance or anything like that. So I guess I'll turn to you on that, Ms. Pritikin.
So I'm just reading another DPS notes here. It says the state is objecting to the rescission of no contact order. There's no substantial change in circumstance warranting a modification of the conditions of release. At the preliminary hearing, the court imposed heightened bail and this no contact order, understanding the seriousness of the allegations in combination with Mr. Burlington's criminal history, prior strangulation conviction out of Oregon with the same victim. Later that month, the first request for a no contact order rescission was denied. In May, Mr. Burlington was convicted of violating this very order down in Polk County, Oregon. In early June, the court again denied a rescission motion. And when Mr. Burlington files proof treatment compliance reports, the state will be much more comfortable agreeing to rescission. Given the history between Mr. Burlington and the victim, the state maintains that the rescission is inappropriate at this time.
Can I speak, Your Honor?
Hold on just a minute, okay?
Okay, sorry.
Apparently, the victim filed proof that she's in treatment, but really that's not what the state is looking to address.
So I've signed multiple releases of information. I go to weekly therapy appointments once a week. I'm actively seeking my mental health and mental health treatment and doing everything that I need to do and supposed to do. I really just I'm trying my best. I'm at a loss of words right now. I've been away from my kids for several months and I've been doing what I'm supposed to do. I get that. I acknowledge that I broke your guys' order and I suffered the consequences. I paid time in jail for that. I did over 30 days in jail in Polk County for that. And I just really, really need to build these relationships back with my kids before it's becomes too late and harder to do. I'm willing to do anything the court says necessary. I've called weekly, every week, made every weekly check-in with Andre from pretrial services. I went over there to do everything right away. I've been super proactive in trying to.
Yeah, Mr. Burlington, just hold on, okay? There's just a few points that have to be addressed here. One is you're on this diversion. You've got to provide proof to the prosecutor and to their diversion agent that you're doing the things that you're required to do regarding treatment. So that's between you and the prosecutor, not with the court. Now, I don't have that information or access to it at this point. So other than you telling me about it, there isn't anything in the record.
So at what point?
Yeah, Mr. Burlington, it's really like bad manners to interrupt me when I'm talking
sorry
about this case, and that applies all the time, court, everywhere else. Okay. Now there's another kind of major issue in this case besides the lack of information that's been presented to the court, and that is that the Superior Court has 2 protection orders involving the 2 of you as well. So any action that happened here in the context of criminal no contact order wouldn't change the situation on the ground. There's still 2 civil protection orders in place in Superior Court that are separately preventing contact. So
Can I say
I'm
something?
confused. What does that mean, Your Honor? Because from what I understood, I just had the one. I only broke the law the one time, or I guess twice. Once by making the contact, but initially I don't understand why there would be 2 different violations. I know that like her family put one against me, but I had never even had a negative word with those people, and I've been doing everything that in my power to do this right thing, and I just don't know, like, what more? Like, I've called free trial services every week. I've went to every therapy appointment every week, even before I was required to. I've signed releases of information as soon as they asked me to. I've signed them to my lawyer. Like,
okay.
I've given
Yeah,
proof that
Mr. Burlington, you've already said that. Okay, so you don't need to repeat that.
Can I say something?
I don't understand why there would be 2. That's what I'm asking. Sorry.
Yeah, there's no answering the question.
What I'm telling you, and it will not change in the course of this hearing, is that there is no information in the court record about compliance with the conditions that you agreed to with the prosecutor.
And so how do I go about that?
State of the record in the case. All right, and Ms. Burlington, I know you brought this request to change the order, and there has
Yes,
to be.
it would be the best thing for my family. Having contact would be the best present I could get for my birthday today, and for our kids. Our kids need our. He's a great husband. He's a great father, and I mean, from what I hear, he's been. I talked to his attorney. I see every time that we went to court that everything has been done. I don't understand why it's not in your records right now. Our kids need their father, and we want him around. The courts put this no contact order in place, and I never wanted it. I never wanted him arrested in the first place. And this has just gone on way too long, and you guys are making us homeless due to this, because he is our only support. I am pregnant right now. I am pregnant. I have 1 more month left. He's missed my whole pregnancy. I need his support with the kids. I need his support with finding a place to live. I need his support financially and physically and morally with the kids, with me, with our new child being born. I need him around, and this is not fair. You guys are ripping a family apart and creating us to be homeless. And that's the truth of it.
Like, if you guys want the records.
Today.
All right, so I'm going to have you both just pause here, okay?
I'm sorry, I'm really overwhelmed right now.
I know everybody's emotional about this, and it almost sounds like you're desperate about it too.
I am.
I want you to
understand. It's been going on for 8 months, Your Honor.
All right, I don't think we're having a productive hearing here, so I don't seem to be able to communicate anything to either one of you.
Well, I just want to know what can I do to bring to you to show you that I've been doing and complying. Like, it's hurting my heart that I'm away from my children.
Right, I've tried to explain this. I don't feel like I'm getting anywhere with it, but
please explain it to me, Your Honor, please.
All right, Mr. Burlington.
Yeah, how can he do that though?
All right.
Please, Your Honor. How can I prove it to you? Like, I've done everything.
I'm going to call this hearing to a conclusion. This is not productive, and it's devolving and becoming repetitive.
Let's fix that. Let's fix that.
Please tell me. I please just need the answer. I just want to know what I can do to take care of this. I can drive you the proof of the records. I'm in Salem, but I'll drive you the records. Like, I will drive all the way up there and give you whatever you need. Like, I just need my family back. Like, it's driving it's this alone is pushing me over the point. Like, I can't even comprehend like how the state is continuing to do this to my family.
Okay, I've had the clerk mute both of your microphones, so you won't be able to interrupt any of the proceedings here. I want to just bring this to a close. All right. So there's a motion before the court to modify a no contact order. The motion is denied. The reason the motion is denied is because there isn't any evidence in the court of compliance with the conditions of the diversion. That may change. There may be information forthcoming. There may be information that's being held by the diversion coordinator that the court's not aware of, but the record in this case doesn't support current compliance with the conditions of the diversion. The prosecutor was trying to make their record as well. Ms. Pritikin, was there anything the prosecutor needed to add to this record?
No, the state really needs to see proof of compliance with the treatment. And even on top of that, there are clearly concerns about the history with these two, with the victim and the defendant. So as you said, there's concerns. It's a two-pronged issue. We don't have the compliance reports. There are concerns even with the compliance reports about the history of violence in this family.
Okay, in that case, then I think that the record for today is complete. The motion to modify or rescind the no contact order is denied. That can always be noted at a later time with the supporting documentation. That'll bring the hearing to a close.